to begin. And as you know, each speaker has 20 minutes. And we have to be absolutely strict about this. Please be mindful. I will help you to check that you are right, but I rely on you. Our session is on a crucial topic, AI and copyright law. And without much further ado, I give the floor to Professor AKINCI, who is going to speak at the crossroads of fundamental rights, innovation, and generative AI, the EU Copyright Directive. Please use the microphone. Thank you.
Good afternoon. Hello, everyone. Thank you for being here in this last session, and probably we will be discussing the very challenge of copyright law that is currently facing, because it is the generative AI, and we need to make it really clear what is the real tension here. And in 15 minutes, if I will be able to put the main problematic in a clear way, I will be very happy. So there will be a lot of questions unanswered. This is the situation. Okay, let me start with the very foundational concepts of copyright law, which are originality and authorship. We see that copyright law, since it emerged, it is a human-centric copyright law. So we are always saying this when we discuss about AI and fundamental rights, AI and whatever it is. There is always an emphasis on being human-centric. And copyright law, particularly European perspective, which is based on the personality theory, it's not different. I mean, it is really human-centric, and you can see it in the underpinning personality theory, which the work is a kind of reflection of the author, and there is a hidden bond between the author and the work. And also the originality is harmonized by the Court of Justice of the European Union, and it is the intellectual creation of the author that reflects the author's personality in a free and creative choices. So in all these criteria, we see the emphasis on the humanness. It is free and creative choices, and it implies a personal touch, which is explicitly mentioned in the case law. So there is always this kind of emphasis to the humanness and the human involvement in it. And there is another concept of 18th century, borrowed from the humanities. It's not legal thing, but it is the romantic ideal of the authorship. So, which means that authorship and let's put it in this way. The genius mind and soul of a person is the source of the creation. So it puts a lot of significant and elevated importance to the mind and soul of an author. And this is very anthropocentric as well. So, I mean, it requires a human in it. Of course, the current copyright law is not based on the romantic and the humanity kind of thing concept, because it is beyond this personality theory, because it is internationalized, so it can be embedded into trade, and also it has some neoliberal economic theories, because it's expanded and it's not driven just by the aesthetic theories of creativity anymore, so it has much more than this with economic incentives. However, we can see that it still has this kind of residue in it. So it still has, I mean, it still requires a kind of humanness in it. And all the cases against AI, especially in the US, it reflects this kind of discomfort from the right holders, because there is something problematic here, even if it is not just romantic in terms of 18th century anymore. So, this is much more related to the output stage, because you know, when we discuss about the copyright and AI, we need to make it into two: the input and the output process. And the output process still requires some kind of human element. But when it comes to input process, the AI training is it requires a lot of data and a lot of copyrighted works in order to be trained. So this problematic here is the use of copyrighted works without authorization. So this is the input question. So the core question for EU law emerged as this: can copyright remain human-centric while still enabling AI innovation? This is the main problematic here. And on the other hand, it should stay human-centric. Whatever innovation argument emerges, it should be human-centric, because there are some legal and normative foundations for it. For example, intellectual property is protected as a fundamental right under the Article 17 of the EU Charter. And of course, it is rightly argued that it's not an absolute right, so it should be balanced with another rights, mostly freedom of expression or education or access to information, whatever it is. But it should be balanced in a fair way, because it is not an absolute fundamental right. So again, the question emerged: how to protect and reward human creators without paralyzing innovation. I will be more focused. I will be more focusing on in this presentation on the input process, because output process seems like quite obvious. I mean, if a work is generated solely by the generative AI, probably in the world it is not protected. Yeah, we see some other examples in China recently, but the general orientation towards human-centric copyright law in terms of output questions. And in terms of input questions, the innovation is becoming more prioritized, maybe because of some pressure from the AI developers and some political, economic reasons. So, for this reason, we have TDM, text and data mining exception. This is a mandatory exception regulated under the DSM directive, and this is a mechanism for large-scale data processing, and it has some requirements to apply for AI developers. And I particularly put Article 4, not Article 2, because Article 3 is about the research institutions and concentrated institutions, research organizations. So in Article 3, there is a kind of public interest, right holders cannot opt out. But in Article 4, it is a general exception, so right holders can opt out. They say, I don't want to be trained by AI. However, in the provision of Article 4, there is no clear technical standards. It says it should be, the opt-out should be in machine-readable format, but it is not harmonized. I mean, in which way we can express this opinion, I mean, this opt-out mechanism. So this is a real and legal ambiguity here, and one other challenge is the requirement of lawful access, because, you know, AI is generative AI that we use in our daily life. They operate in this way. They scrape the unattended information and data from web. So it is really random activity by them. So in these data sets there might be pirated works as well. So, and also they might not have any lawful access to it. Yeah, piracy is another thing, but first we need to have a lawful access. So it might not be lawful even if it is not pirated. So again, it should be in a way that AI developers should negotiate with right holders. So this is another problematic of Article 4. So we see that in input process, the problems are much more than output process, in my opinion. Even the prompt, the general question to me, as someone who works in this field, they always ask me, if I prompt something to generative AI and it creates something, is it copyrightable? And the question from the US Copyright Office is no, because however detailed your prompt is, there will be always a tiny place that generative AI generates by itself. So maybe it's a bit philosophical, because we cannot create something from really out of nowhere. Whatever we say, the big, the yellow, the funny cat, but maybe you forget something, and it will generate by itself. So it will be not your creation by itself. So your human element, human involvement will be reduced. So this is the problem here. I mean, with the emerging of new technologies, the human element is diminishing here. So we see that input process is much more problematic. It's my opinion. Of course, it's up to discussion. And there is a failure of current balance. So I'm concluding a little bit. So, in my opinion, current copyright law, particularly European perspective, faces two incompatible realities. In the input logic, let's start with the output. It's much easier to put it this way. When we talk about the output logic, it is really individualistic, like 18th century romantic ideals of authorship. So we still requires humanness, human element in it. So it is also democratized by the current technologies. So everyone can create something, and you know, for copyright, novelty is not a requirement, so you can create something copyrightable by yourself easily. So it is a kind of individualistic, but when it comes to input logic, especially AI developers are treating right holders as a collective entity, but in reality they are just one single person, or yeah, it might be driven by economic and maybe work for hire doctrine in the US. Yeah, maybe it might be more than one person. I'm not saying it about the quantity. I mean, it's about the human and personal touch, like the Court of Justice harmonized. So the input logic is data-driven and it's collective. So it requires right holders to opt out by themselves against these big companies. So maybe the very problem here, one single philosophy of copyright can no longer accommodate both. But what will we be doing then? So the system, I mean, the current developments always push us to choose between authors and innovation. But in my opinion, it should be still human-centered. human-centric. So just solely AI-generated works cannot be copyrightable, and AI cannot be the author, because it's not because of the capability of creation, but it also has some liability perspective, which I will be going into detail here. But for the input process, maybe we can prioritize the logic of fundamental rights and the fair balance theory, because we said it's not absolute, right? But it is legitimate trading as long as right holders are compensated. So we should be focusing more on the compensation. So we cannot say that innovation is much more prioritized here, so copyright should be no longer human-centric. In my opinion, it will fail in the end, because it has cultural and diversity and the development of society perspective as well. So it's not just about one person, but it's about the society as a whole. So if we split the input and output processes, so in my opinion, we can have some more clearer mind. I don't know. I still have questions about it, but this is my result. So in the end, it should be human-centric, and the right holders should be compensated, and only insofar it will be legitimate in terms of input. So I think after my presentation, the other presenters will go into details of output questions as well. So I think it will be very logical division as well. Thank you so much.
Thank you for this fascinating presentation that really puts the finger on fundamental questions. And thank you for sticking to the time. I now give the floor to Professor Ashiko Group for dealing with training AI on copyrighted content. Will the European Court of Justice clarify the scope of copyright exceptions for AI?
Thank you, Professor. And thank you. I'd like to extend my sincere thanks for the Center for Cooperative Law to organize this event and give me the opportunity to present my work today. I am not the one who will focus on opt-outs, since Ms. EKEN underlines the importance of inputs process. I would like to discuss the importance of inputs. Today, today I will discuss how generative AI will reshape our information ecosystem, and why the legal choices we make, how this creation of information is important for also journalism, pluralism, and information democracy. Before going down to the legal rules and policies, I would like to share one captures to show us the, one of the core tensions behind this topic, I think. In 2024, the most shared image on, from Rafa was not captured by photographers, journalists. It was generated by AI. So why? Perhaps it is easy to share, perhaps it is more symbolic, perhaps it is much more for the users' newsfeed. There should be a lot of reason behind this choice, but choice values something. It has a generative AI, or AI will not only replace the human rights, human itself, human birth, it also replaces the human experience. So, although this example is not related with the copyright issues, it shows us its impact on the substitutive effect. So, the generative AI and AI is no more longer the tool we use occasionally. It's a tool, it's a direct tool, we can access the data, we can produce data, and we can circulate it. Here is my roadmap for today. First, I would like to show the problem at AIDS. Then I would like to present you as stakeholders in this ecosystem. Then I will very briefly touch to the legal system, since thank you, Erva, you did it already. And also from the maybe after the Erva's point, I would like to deep down on the Light Company and Google Ireland case, which is expected to enlighten us. And since we don't have the decision yet, I would like to talk about the possible futures, and if I have time, I would like to say also something about the Turkish current position. So, the Rafa example is not just an anecdote, it is also an early signal of the future. I illustrate this two extremes with Prof, with generative AI tools, and you can see the right side of the slide. There is a hand of AI picking the content. Why? As a result of overprotection, if we create gated contents, gated verbs, so AI needs to pay for use them for training process. So AI will be selectively, and the independent and local publishers lose their visibility, or they force to pay their rights to obtain a visibility. Another extreme is like a free flow data, which means everything will be accessible for input process, and generative AI can access everything. Everything will be accessible, remixable, and reproducible. As a result of this world, we can see the desks which are empty because journalism and publishing is already collapsed, because they lose their economic base. And yeah, we see this empty desk here. So the main question here is, I think we need to understand both two extremes has one result, the erosion of reality. And if we don't want the erosion of this kind of reality, and we still want to have a real content, we need to make a policy choice. Because in two words, AI still remain. There is no doubt AI will find their way, even they need to pay or they use another tools, they will remain in the future. But we need to think about how we balance the stakeholders' desires. So here we have four stakeholders in this ecosystem. First one is right holders and developers, platforms, public, which means us. And very basically, right holders asking for regulation and licensing. AI developers need frictionless access. Platforms need a scale and control, and all we need is actually diversity, trust, and affordability. So, as a result of this stakeholder impact matrix, we cannot see the problem as an innovation, as a conflict between innovation and big company versus the copyright issues. It's more comprehensive than this. So let's see how the different legal systems come over or try to come over this problem. The EU system has a structured regulatory environment on this. I will elaborate it in the next slide in detail. And the United States has a fair use doctrine, which has a much more market effect focus. And even the fair use doctrine finds a more innovation friendly. Still, nowadays, lots of scholars argue that the blanket AI training process will not stay by the fair use doctrine because of its scale, its substitutional effect, and also access license market. So, and also when we turned our look to Turkey, in Turkey we don't have an explicit D10 exemption and really AI-focused legal rules yet, and there are much more the right holders claimed much more based on the unfair use competition. And for my presentation, the most important part is that under the Turkish copyright law, the facts and news as such are not protected within similar to the EU system. So what EU had, Ms. Akın already presented, and also she mentioned how they are struggling in the practice. I want to point out some of them. Output frictions is really one of the central points of this debate, because not only scholars but also practitioners say that machine-readable and democratic platforms is not available for doing opt-out. And also the main criticism about the SM article 4 is this article was framed without generative AI was in mind. And also still enforcement gaps and very short extract tension still be remain between the developers and right holders. Even the very short extract problem should be finalized by Court of Justice before, by saying the 11 words is beyond the very short extract. This is still one of the tension between this case we can see here. So all these unresolved questions now sit before the Court of Justice. Here is the case, the Light Company and Google Ireland. In this case, the Hungarian publisher discovered that Google's chatbot, Gemini Bard, summarized its article, but not just headlines, but also its fragment of its narrative. And it causes a no-click through the website, publisher's website. So no-click means no traffic and no revenue for publishers. And so as a result of this discovery, this issue, publisher argued that publisher claimed that it's a reproduction and it has a substitutive effect. And Google replied, Google defended itself, there is no reproduction and it's not substitutive effect because I put also a link for the user who want to go through. And also, I'm not, for my input process, I'm not making the copy or reproduction, it's just a linguistic pattern learning system. And the local court could not solve this issue, and now these questions, these case turned sit on the Court of Justice. The first question was about the opt-outs, and second and third questions was about training process. In the second questions, court asked the Court of Justice should LLM training based on observing and matching linguistic patterns will be deemed as a pre-production. This is very important questions because it is not generally act of AI's action. It is much more specified with LLM training process. So we will see if the Google's explanation about its technical data will help itself or not. And the answer of the second question is yes. The third question is can the DTM exemption Article 4 will save this process, this input process. And also the fourth question is if users prompt triggered to this content which users show, who will be the responsible? To sum up all this question, we expected to have an answer of the big question. Will AI training become a licensed activity or an exception-based activity? So that's why this case is very crucial. As I said before, since we don't have decision yet, I want to talk about some possibilities. In first scenario, court apply a narrow approach. which means the training, neither training nor the output process will not saved by DCM4 as an exception, and say that also training process is a kind of reproduction. In this decision, let us to through the first extreme, the overprotective word extreme. And as a result of this decision, I think all the AI developers make a lot of ask the EU institution to applicable and efficient mechanism for licensing. Because they would like to, if they pay, because if they pay, they would like to be sure the right holders do not opt out it or any other detail they need to clarify. The second option is a balanced version. This balanced version also should be the heart of the EU framework, because they aim at a balanced approach, and this is why this case is important, because this balanced approach now tested before the Court of Justice. And if court follows a balanced approach, this means training will be saved by DCM Article 4, but the outputs need to elaborate by standards. So in this balanced world, all stakeholders will ask the EU institution to have a standard. And in this world, also many scholars will argue that we have already these standards within the scope of the AI Act. So this, the balanced approach will be a most create debate, I think. The last one, broad approach, court will save the training process and also the partially opt-out process with applying the Article 4 of DSM. Only the exactly same copying of in the outputs will be following the scope of the copyright actions. In this world, it's kind of the general and basic principles will turn, because since the AKIN already explained us the centric, the main base of this copyright law framework is protecting ex ante, not ex post. In this world, we need to some ex post compensation process. So, as I say, we cannot find a direct solution from the Court of Justice decision. It will just point as a policy item. EU will decide which value EU wants to prioritize first. So if we have this decision, this approach, then we need to ask again our legal rules effectiveness. Each policy has clear pros and clear benefits and clear side effects. The role of the rule is not make everyone happy in this world, because I think there is no way to make everyone happy. It's equitable. So the role of legal is here. Whichever policy chosen by us, legal rules guarantee that should guarantee that none of them turn to one of the dystopia, as I explained in my first slide. How much minutes I have? Right. Okay. Very brief and very short current posture and pressure regarding the Turkey's copyright world. Currently, we don't have AI-based copyrighted law, they say. And it's very easy to say our copyrighted law was born in 1950s, so it's outdated. But I'm not really agree with this opinion 100%. We have still base, and we need to understand its tools and its main based, I think. But yeah, we can say that we don't have the DTM exemption under the Turkish copyright law. And currently, there are also scholars argue that a different approach. One side say that it's uncertain area, and the other side say that no, it's not uncertain area. It is illegal activity of copyright AI training. So what happened in the practice, since not also the publisher side, they cannot say on the copyright protection. They use unfair competition claims to fight with the not AI but Google search results. So we can say that our publishers awakened us before the AI explosion in our life. It was triggered by Google search results. And nowadays also press publishers went to the Turkish Parliament to ask a EU similar solution. And also the head of chairman of commission made some statement about they are also working on this kind of drafts. And yeah, what can I offer for Turkey? Recommend for Turkey? Yeah, it's as also all of us said before, it's a very challenging issue, and not setting similar rules will not solve the problem. So I think first we need to revisit the rationale behind our current model, and we design the real stakeholders, our real stakeholders on the table, and we need to understand their desires, demand, and then we try to rebalance them. So copying an EU approach is another solution. If we want to inspire one of the legal system, maybe EU member states regulation process and their paths will show us something, but copying DSM will not solve all the problem, and also will create also problem. Since also the DSM world is now before the Court of Justice, we need to maybe find this decision as well. So my last word, sorry I don't have a solution in my presentation today, but I would like to mapping the options and address what is the real question is. And I think the rule-making process should be a distributional choice, because now we are here to not conflict with two persons. It's not just an AI and right holders conflict. Since I said public as also one of the stakeholders, because it is not indirectly affected by these rules, it is directly affected for this rule. So public also needs to be seen as a stakeholder in this ecosystem. We should avoid the eggs. I know it's very hard to do this, but we need legal rules to do this. Now EU solution is before the Court of Justice, and if we are in a game, I bet the court will have a balanced approach, which will be a more problematic. But because the balanced approach is nothing with a clear metrics and clear standards, and for the Turkey, the path is easy but not easy to walk. First, we need to really understand our rationality of our legal system, and I believe the really contextual comparative analysis on this area before setting legal rules. Thank you so much for your attention.
Thank you for this very interesting and realistic assessment of the current situation. Now I give the floor to Professor EKEN. The topic is the examination of AI-generated content under the requirement of distinctiveness within the framework of intellectual property law.
Dear professors and colleagues, I respectfully greet you all. I wish to express my sincere thanks to the organizing institutions for kindly providing me with the opportunity to contribute to this distinguished academic event. Artificial intelligence has already changed how we think about creativity and authorship. Recent studies suggest that AI may reach half of human creativity by 2040 and possibly equal humans before 2018. Today, AI-based generative music systems such as Sound, Advan, and Boomi can compose complete songs within seconds. Aaron, a painting algorithm created by Harold Cohen, has produced artworks exhibited at the Tate Gallery. Today, AI is part of daily life in self-driving cars, healthcare, banking, and online shopping. Tools like OpenAI's Flow-E can turn different texts into images, and Suno AI composes music from short prompts. These creations are not only artistic but also valuable. For example, the AI-generated portrait Edmund de Bellamy sold more than $400,000, while robotic dogs named Beijia, Wanya, and Bunny produced paintings that reached $40,000 at auction. Such examples show both artistic and economic value, but they also raise important questions. If a generative AI creates something new, should these works be protected by copyright law at all? Who is the author? Who owns the rights? Should these works be protected by copyright law at all? My presentation explores these questions. It focuses on whether AI-generated products can qualify as works under Turkish law on intellectual and artistic works and comparable systems, and whether authorship can be attributed to them. Before we move to legal discussions, let's first understand what artificial intelligence shortly really means and how it functions. The concept and functioning of AI is very important for my presentation. I will give a brief explanation. In simple terms, artificial intelligence refers to systems that perform tasks requiring human-like intelligence, such as learning, reasoning, and decision-making. AI mainly relies on machine learning and deep learning. Machine learning allows computers to analyze data, find patterns, and make predictions. Deep learning is about neural networks. Deep learning uses layers of neural networks that enable AI to learn from experience. It is similar to how humans learn from experience through feedback or something. With these abilities, AI can now write stories, compose music, or paint images that seem creative. But can machines really be creative? From a technical point of view, maybe the answer is affirmative. Yes, they can generate new and surprising results. But legally and philosophically, creativity requires understanding and intention. If an act is not based on free will or purpose, can it still be called creative? This question naturally brings us to the other question, next issue, how the law defines a verb and what role distinctiveness plays in that definition. According to Article 1b of the Law on Intellectual and Artistic Works, a work is an intellectual or artistic product that reflects the distinctiveness of its author and fits into one of the recognized categories such as literary, musical, or artistic works. For something to be considered as work under the Turkish copyright law, 3 conditions must be met. First, it must fit into one of the recognized categories, like literary, musical, or artistic works. Second, it must reflect the author's individuality or distinctiveness. And third, it must be something that others can perceive. For AI creations, the first and third conditions are easy to satisfy generally. However, the second condition, I mean distinctiveness or individuality, is the real challenge. Distinctiveness means the work reflects the personal creativity and choice, something that arises from human intelligence, thought, and emotion. In Turkish law, as in many systems, only natural persons can capable of this, can do this. Some scholars argue that advanced AIs, I mean generative AIs, or AIs that autonomously works, have reached a level of autonomy that allows them to make creative decisions and creations. They refer to systems like EKEN, which writes poems and music almost indistinguishable from human works. However, the prevailing opinion is different. According to this prevailing opinion, genuine creativity depends on freedom and conscious intention. Machines cannot want to create or decide what to express. Their outputs are determined by algorithms and data, not by inner thought. They imitate creativity, they do not experience it. Therefore, AI outputs may look original, but they lack legal distinctiveness. Under the Turkish law on intellectual and artistic works and comparable systems, AI cannot be recognized as an author. Now that we've seen why AI cannot be an author, the next question is clear. If not AI, then who can hold the rights to these creations? If AI cannot qualify as an author, the doctrine mainly focuses on 3 possible approaches. First approach is granting rights to human contributors, like programmers, investors, or users. This approach is mainly based on provisions of United Kingdom, Ireland, and New Zealand regulations about computer-generated products. According to these provisions, in the case of a literary, dramatic, musical, or artistic work, which is computer-generated, the author shall be taken to be the person by whom the arrangements necessary for the creation of the work are undertaken. Second approach is excluding AI-generated works from copyright protection altogether. And the third approach is developing a new legal model that assigns authorship by an origin. Let's start with the programmer. Some believe the programmer should be the author because they design all the system that produces the outputs. However, in our view, once an AI begins to learn autonomously, the programmer loses the control over the specific results. They create the tool, not the products. Recognizing them as authors would be like saying a camera manufacturer owns every photo taken with that camera. The investor theory also faces difficulties. Investors may have related rights, according to Turkish copyright law, in certain cases, such as film or phonogram production, but those rights require a human author. In AI-generated outputs, the author simply does not exist. Finally, there is the user. Most users give only short prompts to AI. for example, draw to me a sunset or compose a jazz melody. These prompts may influence the output, but they are not creative acts in the legal sense. In Nova Productions versus Mazuma Games case, UK courts decided that players are not the authors of game visuals because their actions only trigger preset results. The same logic is applicable here. The act of pressing a button or typing a prompt does not equate to authorship. Therefore, none of these participants, I mean programmer, investor, or user, fully meets the conditions for authorship under the Turkish law on intellectual and artistic works. Since these existing copyright models fall short, let's explore what alternative solutions have been proposed in legal theory. The first proposal is the public domain approach. According to this view, AI-generated outputs should be free for everyone to use. But some scholars fear this could reduce investment. But in our opinion, the goal of copyright law is to reward human creativity, not machines' productivity. If no human creativity exists, allowing the outputs to enter in public domain simply reflects that reality. The second proposal is to grant personhood to AI. However, in our view, legal personality requires consciousness and intent, neither of which AI possesses. In our opinion, granting rights to an entity that cannot understand or decide would contradict of the fundamental rules of law itself. The third proposal is the principle of control, inspired by the United States made for hire model. Here, the person who controls or operates the AI would hold the rights. But Turkish law does not recognize this concept, and AI cannot be treated as an employee capable of entering contracts. Moreover, this model focuses on ownership and control, not creativity, which conflicts with the philosophy of copyright law. So, after reviewing these options, it becomes clear that current approaches are not sufficient. Let's now turn to how a balanced and human-centered solution could look. When we bring all these points together, one main conclusion emerges. Under Turkish law, a work must reflect the author's distinctiveness, I mean human creativity and distinctiveness. AI products, though often fascinating, are based on algorithmic processes, not conscious human choice. Programmers, investors, and users each contributing something, of course, coding, funding, prompts, but none of these contributions express genuine creativity. Therefore, AI-generated products cannot be regarded as works under the Turkish law on intellectual and artistic works, and should, in our opinion, at least for now, be considered public domain creations. However, AI outputs still hold significant economic value, and companies invest heavily on them. So we should protect their investments, I think. To protect these investments, a sui generis protection system could be introduced. Turkish copyright law is familiar with this kind of protection, from the one for database producers under Article 8 of the Turkish law on intellectual artistic works. This article shortly says that the maker who made a substantial investment in a database has the right to authorize or prohibit the use of its content. This system would not treat AI as an author. Instead, it would grant limited rights to those who make substantial investments in developing AI systems. Such a model would promote innovation while preserving the human foundation of intellectual property law. The protection should also be time limited, of course, around 15 years, as in database rights, since AI has no life, consciousness, or habits. To sum up, AI challenges our traditional understanding of creativity and authorship, but instead of expanding the notion of authorship to machines, we can preserve the human meaning of creation. The sui generis investor right offers the best balance by rewarding investors' investment while keeping creativity focused on humans. That concludes my presentation. Thank you very much for your kind attention.
Thank you, Professor EKEN, for this presentation that streamlines several problems and paints to possible solutions. Now I give the floor to Professor AKINCI. Open source, open weights and trade secrets in AI, navigating the tension between transparency and competitive advantage.
Hello, everyone. Thank you for staying at this hour. I hope it won't be as taxing as I imagined during my presentation. I will be talking about open weights, open source, and trade secrets in specifically AI models. Whether it can be protected by contracts or copyright or trade secrets. Well, let's start with what is open weights and open source. Okay. So, we have here model weights means the fundamental numerical parameters that define a model's behavior. So, it is just a bunch of parameters that have certain weights in them. I will talk a bit more on this topic a little bit on the next slide. So it is essentially what the model represents. And when we talk about the open source, we will include this weight plus a training code, how we train this weight, and plus other codes that actually designs the learning structure of the artificial intelligence. So when we talk about the open weight, it is quite different than the open source. We will only talk about the weight itself, that is freely available to the public. And lastly, when we talk about the proprietary models, like the closed models, there could be like GPT-5 or Anthropic's closed models that are restricted, cannot be downloaded to your laptop or workstation, can only be accessed through an API or a web application. So, what are the weights actually represent? So, if we give an example, for example, in this sentence, we say that under Turkish civil law, the court may award non-pecuniary damages. So, we can see that if it is in a legal corpus, if it is a legal text, model will highlight these terms, thinking that this has higher importance, so does have high weights. So this weight parameter actually represents how an artificial intelligence model understands your input and then goes for the output. So this just tells the model how important is this signal. So why the open source and open weights are actually matter and why I am talking about this? Because the models being opened are no longer small models. So open weight models that you can download to your laptop or you can download to a workstation are quite big and quite close to closed models like GPT-5 or Google's Gemini. So, and also open weight models publicly competing with the GPT models on the market share. On recent news, for example, DeepSeek actually outcompeted GPT-5 on a real financial interaction. So it gained more money through $10,000. I believe they gave them each $10,000 and instruct them to invest as they see fit. So DeepSeek actually gathered more money than the GPT-5. And actually, these are also important from the legal perspective because regulations differentiate from closed models than free and open source models. So, open source models are not just for the DeepSeek, like these Chinese models or Meta's Llama models. Even big providers like Google have open weight model like Google Gemma. OpenAI have even released a GPT OSS, a GPT open source software models. Recently, XAI released Grok 2.5 freely, and Mistral have quite a bunch of variety of models that are free to download and use it on your own system without accessing to the internet. So, how these models are legally protected? We have three options: trade secret, copyright, or contract. So when we are downloading these models from a free website, it is unfortunately for them that publishing on the internet would remove the secrecy. So there won't be any trade secret protection because trade secrets, as in the US or EU or in the Turkish legislation, requires a secrecy and measurable protections to be implemented for that to be actually get the benefit of trade secret. But the closed models could still benefit from these trade secret protections because they won't release their models. So can we get the protection from the copyright? Unfortunately, unlike the output or the input discussions, models are actually does not have any original materials in them. As I just explained in the weights, they are just mathematical representations of certain knowledge. They do not have any meaningful sentences inside them, just mathematical numbers and their correspondence. So they would not have any copyright protection whatsoever. So if they don't have trade secret or any IP protection, what can they rely on is the contracts. So the contracts, if we interact with the closed GPT-5 like models, we agree on whether it is a click grab or whether it is an I consent button or a checkbox. We agree on certain term of use once we are using their website like ChatGPT or their application on our phone. But the open weight models, we actually download them. We don't need to even download from them. We can copy it from someone else. They do have sometimes associated license file just alongside the current weight, but it doesn't actually have legal enforceability of the website application consent mechanisms. So also ChatGPT knows who you are actually, a little bit have knowledge of you because you are a user, you are using certain type of usage you have your own IP address, you have your own login credentials. But if we talk about an open weight model like Llama or a DeepSeek, when you download them and without an internet connection, even with the internet connection, if you run them on your laptop, they won't be able to know that you are actually running them. They are an offline programs and they don't require a server connection. But they do still have contracts, like Google's Gemma and Meta have acceptable use policy and standard terms of use. They do have includes some of strange clauses in there. For example, Gemma claims that they reserve the right to restrict remotely or otherwise usage of any of the Gemma services. So they claim that they can stop you using Gemma's model on your own laptop remotely. So I don't think that's technically feasible, but they would believe so it is feasible someday maybe. And the Meta, for example, to avoid the DSA and the GDPR, on their term of use, say that if you have domiciled in the European Union, you cannot use these models, but they don't know who you are and they don't know where you are. They cannot actually prevent that, but it is in their contract. So why these models are in the market? Let's see from their perspectives. So the publisher's perspective, it is not just a transparency or goodwill. It is quite a competitive agenda. We all heard about the DeepSeek, right? When we heard the DeepSeek, when it's released, NVIDIA's share capital is actually plummeted. Why we heard of that? Because they were open source. Otherwise, no one would be able to use the Chinese models through an API, because we can install it on our own laptop freely without giving a single dollar. And it is a marketing strategy, it is a market strategy. Even Meta have released all their models as an open weight because they know they cannot compete as a closed source quite easily with the OpenAI or Anthropic, because they released it under an open weight strategy. They were able to get to be known quite easily. But they signals that Zuckerberg signals Meta won't open source all of its super intelligence AMLs. So they are still thinking about a closed proprietary approach as well. And Sam Altman, on the other hand, thinking that OpenAI should have more open source, open weight models, as the name actually suggests. But as these also suggest, these open weight models are here to stay, not easy to pass phenomenon. But they do have certain problems, because when we use a ChatGPT, we know that if there is a problem, like Grok's problems a certain time ago on Twitter, they can fix it. But once they release the open weights, they cannot fix that, because it is out in the public. If there is a problem with their own safety issues, if there is a problem with fundamental rights infringements, it is there to stay. They cannot do that. They have to do all these pre-release. They cannot touch and change how you use that model afterwards. So, from the user and enterprise perspective, we can see that it is quite a cheap solution, because we are not going to pay OpenAI or Google any money. We can install it on our computer, and we just have to only pay the electricity and one-time installation cost. We can see that it is a privacy compliance, because our data are staying in our computer, not going anywhere. We can fine-tune the model, which is only possible if you have the model in your own hand. You can change it, you can make it learn on your own enterprise company data and act on it more precisely than the ChatGPT's GPT models. But we do have a problem, compliance problem. Since these solve quite a bit of technical problems, they do create a compliance problem. So these licenses Are they able to enforce them? We cannot negotiate with the Google. We cannot negotiate with the Llama. They have these licenses on there, and we just downloaded and started using them. Can this region ban that bans European Union actually be effective? Can the court see the way the Google see the license? We don't know these, so there is a risk parameter still exists. So when we move on to the perspective from the regulators, we can see clearly on the European Union AI Act that a free and open source license is effectively supported. For example, in the Article 53, we can see that there is an obligation for the providers of general purpose AI models, which excludes free and open source license, things that they do not need to obey these obligations. And also, they don't need to have authorized representatives in the European Union if you have a free and open source license. Why are these here? Because they want to support these environments and these initiatives, because it gives you research organizations the free models to use. It takes the costs down, and also it takes the monopoly out of the hands of the providers, which are usually now exception of the Mistral and China and the US. But it also benefits when you are the open source software provider like Meta. And also, for example, Article 25, responsibilities along the AI value chain, we can see that it is not effective against free and open source licensed AI models. So, what we have in here is what I would like to call a perfect storm, which we have open weight models exist and have quite a bit of market share, which are supported by the regulatory approaches and have an active market dynamics, could not go easily out of the fashion in the future. They are source openly available, which makes them vulnerable to misuse rather than the use of the ChatGPT-5, for example. And they are fast. They do release new models almost per week. So you can see a QM models coming in, Chinese model, then the next week coming a DeepSeek model. Then the next week Mistral is freely opening another model, and then Elon Musk is going out of fashion and giving Grok 2.5 as a free download. And you can see the implementation by the companies are quite lucrative and incentivized, but unfortunately they are not protected by any trade secret protections or a traditional copyright or any other type of private law mechanisms. What they have, only contracts, which are quite courageous, what I would say, have some clauses that are not even technically possible and not negotiated. Even if you think about from the Turkish law perspective, they could easily be in a court, say that they are general standards clauses and they are actually need to be interpreted by the court again, because you do not have any negotiation whatsoever. It is just given to you like a bank contract. Then a judge has the flexibility to interpret them as they see fit under the Turkish law. Thank you for listening.
Thank you for this excellent presentation. It was a very interesting panel, very rich of problems, and so now I think we have 10 minutes for questions. Please, Mr. Sanchez.
Very brief. First of all, congratulations. It was very interesting, all your interventions. Brainstorm, say. One question. Is the clear inertia to try to explain this new reality with canons that were not drafted for this kind of reality. First question, is this methodologically correct? Second question, do we have to search for new aesthetic categories to try to explain sufficiently this new co-creation, binary co-creation between AI and human beings? Authenticity is also a problem. Can we measure digital restitution of cartoon objects? I'm talking about it. Thank you very much.
So you have any speaker in mind for these questions? Or they are addressed to the entire panel? I suppose each of you would like to answer. Who wants to take up the challenge?
Maybe I can say a few words. It was challenging for me while I was studying for the concept of distinctiveness and characteristic of author. Okay, sorry. It was challenging for me while I was studying on distinctiveness, concept of distinctiveness from Turkish copyright law, and there's similar concepts in other law systems like originality and creativity, but the idea of hybrid distinctiveness was to be useful. I think we can generate a new concept of artistic copyright products, and we can say this is hybrid product that bears the distinctiveness of AI and people and human. But I think the problem of my study was the source of that creativity. I should focus on the source of creativity, and I search for that creativity with AI-generated products. In my view, AI-generated products, yes, they are brilliant, they are fascinating, they surprise us, but the creative work is made by human. There is no statements in the AI products. Very much.
I can answer as well. It works? Okay. If I don't understand wrong, you asked about if we should provide some new forms of creativity, the understanding of creativity that is the foundation of copyright law. This is what I understand, so within this scope I will try my best to answer. First of all, in copyright law, creativity is a kind of source for originality because it has to be free and creative choices. But on the other hand, the threshold for originality is really low. It's very low. I mean, it doesn't have to be very aesthetic in terms of humanity's perspective. That's why during my presentation I mentioned the romantic ideal of authorship, because it was the very before the copyright law emerged, and the idea behind the romantic ideals of authorship is the admiration towards the human mind and soul. So this is really still very attractive to us because it is the source of creation. But the threshold is very low. Even the kindergarten photographs of children are considered original, even if it is within the scope of a photography job. You know, in school they take our photographs just to identify us. It's not, I mean, it doesn't have to be really aesthetic with emphasis. So, first of all, the aesthetic is a little bit tricky concept for copyright law, but on the other hand, it is rewarded because the foundation comes from this anthropocentric foundation. For me, for AI, should we revise the definition? I don't think so, because just because AI can do it very easily and very quickly, why we record it? Because it doesn't benefit anyone else. I mean, and also the novelty is not the foundation for copyright law, so it shouldn't be the novel. I mean, you understand what I mean. So I think when it comes to AI, our current human-centric concept of authorship is more than enough. So we don't need to revise it. Yeah, this is what I understand from the question. Thank you.
Please.
Stakeholder Management and Policy Specialist from Koç University. I will rephrase same question, but from a different perspective.
I'm not sure if the microphone is working.
Can you hear me?
Now, yes.
Okay. I will rephrase the same question, but from a different perspective. I don't know, have you read about a news about Star Wars movie? A high school student recreated a new episode of Star Wars within 11 days and 11 minutes video. But it was better from the original, you know. All the comments, it was excellent. But he used the previous visuals from the original movie. And there was another subject on Hollywood. They want to make the digital copies of actors' sound videos. There was an AI actress, Tilburg, I don't remember the name, but we thought it's real. It's not real. In this case, how is EU frame covers the IP rights? Because the original, they use original movie, but another person, a high school student, recreates. He adds a value there. So what is the perspective we should look at a, you know, I'm not a scholar, but a policy writer, in this perspective within the EU frames?
Okay, quite a burning question. Who is ready to answer?
Sorry, can I repeat that if I understood it correctly? So you are asking if there is like an episode of the Star Wars movie that is made by the AI by someone, high school student. How should we protect it? Why should it be protected? Was that the question?
From the IP side.
From that.
He used the original.
Yes.
But he created something new. He added a value. So, how will we manage this?
Well, yes, that could be answered quite differently from different legal systems. In the US, they are now arguing that over the case law that is mentioned here also, New York Times versus OpenAI. So the OpenAI actually claims that they have been using that knowledge, that articles, and used as in purpose of transformative use, which they believe to have a fair use exceptions triggered by that sense. if that exception is triggered, then the new the models and the outputs are actually protected. Sorry, they don't know. I don't know if they're protected. They think that the infringement does not exist because there is an exception, but the protection of the output always comes back to the problem of authorship. So the originality problem and whether we can protect something that is not created by the humans. It doesn't matter whether you actually based on something that the humans are actually authored it. It does have some degree of blow of sweat protections could be exist in some countries that actually recognize them, like before the EU, the UK actually recognized that kind of protections that does not have any originality but have quite a bit of investment into it. Otherwise, in the end, you may not have an original creation, but you still have infringement in your hands because you use someone else's file, copyrighted material without getting the proper authorization.
It works again. We also, I think, need to visit the adoption right holders. Adoption right is a kind of when you have a scenario or story of one author, if you want to make it in a movie, or you want, if you have a text and you want to translate it, first you need to ask for permission of the right holders, the first right holders. In this AI world, we think that we don't need this kind of permission to make any adoption of this first work. But I think it's because we miss something. If I can do this, yeah, I can do this. But if you want to do this legally, you need to ask the permission of right holders. So I think in this case, if the Star Wars even the story or the cinematography or the series are not open their script for the public, it's an illegal activity. So making this adoption is an illegal activity. So this is what we are talking about, how we legalize the input process actually. Since this kind of AI models actually not legally obtain this script in their system, we have this problem. And in this world, this AI developer said that yeah, this is the user responsibility, but it is not the user responsibility actually. If we have that's why the training process and the source of the training process is really important for also opt-out, because opt-out will be a unique, or we can say that opt-out is artistic work or not, but it's also really important which base we apply for creation of this work. I hope it will happen.
I think we can take one last question before closing our session. But if there is no question, Andy.
Thank you very much. Thank you all so much for your marvelous presentation. Just a thought, it's probably provocative. What if we just get rid of copyright on the one hand entirely, or the alternative, block it off and say only where there's human involvement predominantly, and none or minimal, if there's any kind of machine involvement, it doesn't come up in copyright. So it's just a quick question like that to put things on their head a little bit as we finish off. Thank you.
So just to clarify the question, when you say get rid of copyright, you mean exactly doing what?
We could either completely repeal copyright because it's redundant, perhaps, or alternatively, and it's a deliberately provocative question, but alternatively, only if it's in relation to genuine human endeavour, and otherwise we don't have it applicable at all in this area.
Yes. Okay.
copyright is really very provocative question. First of all, we have many different justifications for copyright law, and from whatever perspective you start with, you end up having copyright, because if you prioritize the economic incentives, then copyright will promote people to create more value, and then it will benefit the whole society and themselves as well. So when you take the personality theory, then there is again the normative value of this kind of bond between work and the author. So also the labor theory, it rewards the effort that is put onto the work. Otherwise, no one would create anything, and it will flatten the cultural diversity, the development. So, in my opinion, it is very beneficial question to keep the discussion going. But in the end, we will, in my opinion, we will have it. But the scope of copyright law definitely should be revised, especially in the age of AI. Definitely, that's why copyright is struggling right now. And I said in my presentation, one single philosophy of copyright law that came from maybe 2 or 3 centuries ago, it doesn't solve the current problems anymore. So maybe we redefine copyright law in a way that it's still human-centric, and because of the fundamental rights perspective of copyright law, the compensation must be essential. So we can make some sacrifices, but we should have copyright, but maybe some policy choices can be diverse. And well, what I was going to say, yeah, I think this question, I mean, doesn't have any answer at the moment from this perspective. And at the same time, the economic theories of copyright law regards the copyright as a commodity, as a resource that can be monetized and that can be traded or owned. So this is like a property, but intellectual property, we say. It's not a real property, but the economic theories leads more towards this way. So maybe this is the problematic. So we find a middle way for both competing interests, and maybe this will be the final answer. Yeah. Thank you so much.
It's very provocative, and it's very provocative. Thank you for this question. It's also on my mind, because not only copyrights, but also the IP rights all over, they mainly deemed as a tool of capitalism. And now, not you, but the capitalism asked to remove them, especially the copyright state. So, I think, for example, in Turkey, we use the copyright protection as also limited the scope of copyrighted works. Because, for example, if you don't have copyright protection, maybe someone asks protection for their tweets as well. Because when we have a copyright protection, we set also some basics which words desired, which words obtain this protection. Also, we have this problem with effects and news protection. Since they are not considered artistic work in Turkey, they don't have a protection. But also another tool for the protection mechanism is Furkan mentioned, database protection. Because under the database protection, copyrighted and not copyrighted work also protected, to make a thank you to the investment efforts. So I don't like that really idea of removing the copyrights, but during my presentation I avoid use copyrighted content mostly because in AI world, AI is not really understand which is copyrighted and which is not. Maybe we need some sign or maybe we need another machine learnable format for this. Also, the current definition of the artistic work will not be really machine readable. Yeah, we need some. I cannot say now the revision. We need revision, but we need to think about it more. Thank you.
Thank you. So we close this session and we reconvene tomorrow here at, if I'm correct, first session beginning at 9:30.